by any other name is negligence. But of course, to be sure, there are definitional terms we can use to illuminate or illustrate what negligence is. And it's fault, it's a civil wrong, it's a failure to act as a reasonable and prudent person or individual or corporation or professional individual, if you're suing a professional entity or somebody who is of a professional status, an accountant, an engineer, an attorney, for example. Now, what's interesting in personal injury law is that you have to prove 4 elements, and those elements are transferable to almost every other kind of negligence case, regardless if it's a malpractice case or if it's a premises liability case, a construction accident, or a case that involves automobile negligence. So what are the 4 elements? The element is, does the defendant, the entity being sued, owe a legal duty to the plaintiff, the person suing? Second question, was there a breach of that duty? Third, was that behavior causally related or connected to the injury that was sustained? This is called the legal cause or the proximate cause. And fourth, did the plaintiff who was allegedly injured actually sustain damages? Those are the 4 elements. And you may say, well, I have a case of this or a case of that. How do those come into play? How do we establish that? Well, we establish the standard of conduct on the negligent actor, the alleged negligent actor, the defendant, by what the custom and practice is in the industry. And we may use other sources to establish what that standard of conduct is, what is expected of that person, that entity, that corporation, or that professional individual. And again, the overriding concept is, did they act as a reasonable engineer? Did they act as a reasonable automobile motorist? Did they act as a reasonable attorney? Did they act as a reasonable accountant? And others in that field, if you're dealing, for example, with professional malpractice, others in that field are the only ones, and the law uses the word competent, that is appropriate to give testimony on what constitutes reasonable conduct, on what constitutes reasonable performance or reasonable care. And again, the concepts are ordinary and prudent behavior, and you fit it into the particular situation that you are given, the particular factual situation in the particular defendant that you, the injured person, are making a claim against. So I want to emphasize that these concepts are very much transferable from one form of negligence case to another. Keep in mind that, as I have said in the past many times, the mere fact that an accident has occurred does not mean that there's negligence. If somebody is hurt on a construction site, just because an accident occurred doesn't mean that the construction company or subcontractor, general contractor, or a particular engineer is negligent. You have to prove that there was a duty owed, that can be done, and that there was a breach of that duty, and on that issue it could be much of the debate. But there are ways that are reasonably clear to establish a breach of that duty. Thank you.